This is video lecture 4, making up for Monday, September 12th, evidence class, and we are in the middle of discussing the possible permissible purposes that evidence of prior acts or crimes or wrongs committed by a person might be admitted at trial, and these purposes are put forth by the proffering party to say, look, we're not offering this evidence as character evidence, but instead for this substantive purpose to prove a substantive issue in the case. And again, I want to remind you that Rule 403 is always hovering over possible admission through one of these purposes, because there always is going to be a danger of improper use of the evidence by a jury, that a judge might determine a limiting instruction wouldn't be enough to overcome that prejudice or other Rule 403 concern. So remember, our mnemonic is SS Kipomia, and we are on the first letter I of Kipomia, and that here is intent. So we certainly remember from criminal law that with certain crimes a prosecutor has to show, say, that the defendant had a particular intent when committing the alleged criminal acts, like intent to steal in a larceny case, or intent to kill, premeditation, right, in a first-degree murder case. Intent is also an element in other specific intent crimes, like knowing possession of stolen property, sort of a scenario like that Huddleston case you're reading for Wednesday, or knowing possession or transfer of counterfeit money, for example. So there's a lot of overlap here between this intent purpose and other ones on the list, because often where you're offering evidence to show knowledge or motive or even modus operandi, signature crime, common scheme or plan, the second inference you want the jury to make when they take in that other evidence is, of course, that the defendant had the requisite intent, especially in a criminal case for the crime. So a couple of examples I have on the slide, on the bottom of the slide here. Let's say a defendant is accused of first-degree murder for shooting and killing his wife, and his defense is, well, he admits he shot her, but he says, look, this was just an impulsive act. This just happened. We were fighting, and she said or did something that suddenly enraged him. So he's making an argument that it shouldn't be first-degree murder, premeditated. He didn't possess the intent, the advanced intent to kill her. Now, if the prosecutor wants to put on evidence that an hour before the husband shot the wife, he actually went to her lover's house and shot the lover, that would probably be admitted, because it does tend to show that he had the requisite intent to shoot her too. He clearly went to shoot the lover and then went back to his house to kill the wife. In contrast, for example, though the prosecutor in that case couldn't get on evidence that, say, sometime in the past the husband had killed someone else, since that doesn't say, of course, anything about intent in the current case. Here's another really interesting intent example from when I was a teenager. Back in 1977, we had United States versus Hearst right here in the Ninth Circuit. So Patricia Hearst, if you've never heard of her, was the heir to the Hearst publishing fortune. Her grandfather was William Randolph Hearst. And in 1974, she was 19 years old. She was a college student at Berkeley, and she was kidnapped at gunpoint by a group called the Symbionese Liberation Army, the SLA. And while she was in captivity with that group, she actually put out announcements that she had joined the SLA. She put out several tapes promoting their causes and sent them to news organizations. and she participated in crimes that the SLA committed, including a bank robbery here in San Francisco in the Sunset District, in which 2 customers were shot and wounded. She was then captured in 1975 and she stood trial for this bank robbery, but she claimed that she was under duress while she was participating in the robbery. And in this case, the prosecution did get admitted evidence of other crimes and acts she committed while with the SLA. The prosecutor got that admitted under this purpose to show her intent to actually rob this bank. She was convicted and sentenced initially to 35 years in prison, which was reduced to 7 years at her final sentencing. And then President Jimmy Carter commuted her sentence after she had served 22 months. And then Bill Clinton, in fact, pardoned her in 2001. So that's the story of Patty Hearst, but an example where a prosecutor used this intent purpose to present evidence of past crimes committed by Patty Hearst. Now, of course, you're going to want to be careful if you see someone in a hypothetical making an argument about admitting specific act evidence, past crimes or past acts as evidence of intent, because you have to be sure that intent is really an element of the crime that was charged there. So for example, I have actually on the slide the Sparks versus Gilly trucking case. This is a civil case where the Fourth Circuit held that the trial court had abused its discretion there in admitting past speeding tickets of Sparks, the plaintiff in the case, saying that the trial court had let those in because the defendant had said, you know, we're presenting evidence of these past speeding tickets because we want to show that he had the intent to race his car or to speed on the day that this accident happened that led to the lawsuit. I'm assuming this was sort of a contributory negligence issue, but the Fourth Circuit said, no, this was an abuse of discretion. These past speeding tickets should not have been admitted. Intent is absolutely not an element in a negligence case, so even if there was in contributory negligence, intent isn't an issue there. In fact, it's not even an issue in an element in a speeding violation, right? You don't have to show that someone had intent. So that's actually use of this kind of evidence or attempted use of this kind of evidence in a civil case. Okay, next in SS Capomia we have the 2 P's. The P's are plan and preparation. So starting with plan. Now this purpose is often referred to as showing a common plan or a common scheme. And in a perfect world, courts would be very careful here because in truth, a lot of evidence that is offered under this purpose is really just character evidence. So it should be interpreted very narrowly and limited to, for example, a series of crimes that are all related to the same specific goal or crimes that could be considered part of the same criminal transaction. Just like with a lot of the other purposes in SS Capomia, plan can overlap with some of the others on the list, in particular things like motive or identity or even intent. Now, courts have certainly been very inconsistent in some cases around the margins, and not every court has really been as careful as I think the idea was originally put forward to promote. Really, each act that's presented should be an integral part of some overarching plan, you know, conceived by the defendant or with co-conspirators. But I want to call your attention to footnote 20 on page 126, where the McCormick piece drops this footnote 20 to stand for this idea of courts that have stretched this kind of beyond the breaking point. They've construed it overly broadly. The first one listed there is the People versus Catlin case. There, that's a California case where a defendant had poisoned his mother with this herbicide paraquat, and the court there admitted that under this um, purpose of being part of a common plan in a criminal prosecution for actually killing his fourth wife with that same poison. Uh, and it doesn't sound like those two poisonings were very close in time together. So, you certainly could make an argument that that is really not uh, what the rule drafters were thinking of in terms of something that could qualify as being part of a common plan or a common scheme. Um, in the paraquat example, maybe that's unusual enough that you could have gotten it in as um, past evidence of some sort of a signature crime modus operandi. But again, here this was upheld when the trial court admitted this as being evidence of a common plan. And then the People versus Ewald case that I have on the slide is also in that footnote, which basically talks about the Ewald case actually overruled the People versus Tassel case, as you can see in the footnote, that the Tassel case had explicitly required in California that in order to establish a common design or plan, you had to show that there was a single continuing conception or plot. So really, California had been adhering to the more narrow version of this, but that Ewald case in 1994 overruled that and basically put in this much broader language saying that the evidence might be admissible if the uncharged misconduct shares sufficient common features with the charged offenses to support the inference that both the uncharged misconduct and the charged offense are manifestations of a common design or plan. But if you really think about that, if you take that too far, you're really actually allowing just any evidence of similarly committed crimes, even if they don't rise to the level of, say, being a signature type crime. And that is really just character evidence in disguise if you take that too far. So I think that the McCormick definitely intended to sort of, with that footnote, to sort of criticize the courts that have taken this plan purpose a little bit too far. Okay, let's look at some more examples. The classic one with plan, where we actually do see the logic of admitting the evidence, is something like, well, evidence that the defendant stole some item needed for the charged crime prior to the crime. So a prior act was committed. For example, stealing a car, stealing a gun, stealing tools to help with a break-in. And maybe those earlier crimes aren't being charged in the current crime, but they certainly could be conceived of as being a part of the crime. So an example of this that I have on the slide is State versus Wallace. And the defendant here was charged with committing a burglary to steal a gun, and that gun was found in his possession. And the plan that was alleged here by the prosecution was that the defendant was actually stealing all these guns to try to reconstitute a gun collection of his dad's. I think the guns had been sold, and this defendant was trying to get all the guns back to reconstitute the collection. So the court here did let in evidence that Wallace here had committed another burglary and stolen another gun that had also been part of the collection, because under this theory that it was all part of a common scheme or plan. I have another example on this slide, U.S. versus Varadakis out of the First Circuit. So here we see an appellate court saying that a trial judge should not have admitted evidence that the defendant here set his car on fire in the past in his current arson trial for setting a restaurant fire. Okay, so the trial court had let in this evidence that the defendant set his car on fire in the past. The appellate court here said no, that was an abuse of discretion. The car fire was too remote in time and also lacked a strong enough link to show that it was part of some common plan. And the First Circuit pointed out, look, you can't simply say that, that you wanted to get a financial gain as a common plan, common motive in setting both fires, say, to make insurance claims. That's not enough to bring this under this proper purpose for actually being part of a plan. On the other hand, this purpose, this plan purpose, is very commonly invoked by courts to let in prior drug offenses on the theory that selling drugs in a continuous business involves a common plan. Now that is a very, very iffy stretch of this rule to let that in. Very, very close to just being character evidence. I have another case on the slide that is also a huge stretch of this possible purpose, and that is the Commonwealth versus Schoening case out of Massachusetts. So there, the court let in evidence in a trial alleging that the defendant accepted kickbacks. So the defendant was charged for accepting a kickback in this trial. The trial court let in evidence of other occasions and other people the defendant had accepted kickbacks from, saying that the other evidence went to showing a common scheme of the defendant to use his position to get kickbacks. So another fairly broad stretch here of this rule, but certainly something to know about, because you could make that argument if you see something similar to that. Here's a really interesting case out of the First Circuit, too, using this common plan purpose. And so U.S. versus DeCicco. DeCicco here was charged with setting his own warehouse on fire in July of 1995. The prosecutor offered evidence here that DeCicco also set fire to this same exact warehouse back in 1992, so 3 years before the current charged crime, under this purpose that there was some ongoing plan to burn the warehouse to collect on an insurance policy. Now, the district judge in the case actually excluded the evidence, saying, no, this doesn't rise to the level of being a common plan. But actually here the First Circuit said this was an abuse of discretion and that the evidence should have been admitted here. So first the court said, look, 3 years isn't that long a time ago, plus it's the same warehouse and the same behavior. But the real kicker here was the fact that DeCicco's insurance company had actually canceled his insurance policy in 1992 after this suspicious earlier fire happened. And he had to wait 3 years to get a new policy on the property. Presumably he got the policy from a different company without having to disclose the earlier cancellation of his policy. And lo and behold, the new fire happens 2 months after he got the new policy. So the facts here actually dictated, I believe, the appellate court's decision, the bad facts for DeCicco. All right, the next P is preparation, and this one really does overlap with plan, also sometimes with opportunity, identity, and intent. So the permissible purpose here is to show specific preparation for the charged crime in a case. So just like with plan, the garden variety examples, common examples that this purpose could be used are things like evidence that someone stole a car to use as a getaway car for the charged crime. Let's say the charged crime is a bank robbery and you want to put in evidence that the defendant stole a car because he needed a getaway car. Or breaking into a store to steal tools that were then later used in a charged burglary to break into a place. Now, of course, both of these overlap with identity. They certainly help show that it was this defendant who committed the crime at hand. Intent is another thing that can be bolstered by evidence of preparation, anything really that helps prove premeditation. So sometimes using the preparation purpose can also go along with proving intent. So one case I found was about a defendant who was accused of assault, and he was claiming self-defense after a fight in a bar. And he was claiming self-defense, and the prosecution successfully got into evidence that he had actually put brass knuckles in his pocket before going into the bar. I thought that was an interesting one, showing preparation. Or I also have one on the slide here, breaking into a gun store and stealing a weapon before killing someone. Obviously, that comes in under preparation, but it also helps show intent, right? Because it shows premeditation to kill. But there's a very interesting old case that I have on the slide, People versus Zakowicz from 1930, a New York case. Here, the defendant's wife was insulted by a bystander, and he went home. I guess they were in a crowd somewhere. Defendant's wife was insulted by this bystander. He went home and returned with a pistol from his house that was then used to shoot the bystander. Now, the defendant here claims self-defense, saying, oh, yeah, that first little kerfuffle we had with the guy who insulted my wife, that was totally over. I was completely over it. And in fact, you know, this incident happened, the shooting of the guy happened because there was a new conflict that came up, and I felt threatened, so I had to shoot the guy. But here, the prosecutor wanted to introduce evidence of other weapons in the defendant's home to rebut the self-defense claim, which is kind of interesting. And this wasn't allowed here, and it doesn't seem at all like a close call. Although in dictum in the case, the court said that if the guns had actually been purchased prior to shooting the victim, that if he had gone out to purchase the guns prior to shooting the victim, then that would have been admissible. And in truth, you'd think that the prosecution here would have had enough evidence just with the fact that they were allowed to put on evidence that the guy actually left and went home to get his gun. So they were sort of going for additional pile-on evidence here, wanting to put on evidence of other weapons that he had in his home and purporting to offer that under this preparation purpose. Okay, that's the end of this last video lecture for the makeup class. So I will see you in class on Wednesday.